But a noose in the cells, very terrifying prospect.
Yes, sir.
Because the thought is, the next time there's a noose in your cell, there might be a person in it. So we need to make sure that we
final
are
violation
hearing.
So let's come back on.
Here's where we're at, Mr. Stutz. You know, Officer Henry's been listening to your jail calls, and all you talk about is cutting off your monitor and heading
We're
out.
today for a pre-trial, but it's my understanding Mr.
And-
Stutz is going to enter a plea of guilty to one count of violating a protection order. Is that accurately stated?
That's correct. He would like to read the court a statement regarding bond.
I'm asking you to please put me on probation and let me back out to my family. I've been locked up on these charges since 10/10 to 25. I'm not on any parole or probation. I have a job and a support system. I have not picked up any felonies and only 2 non-driving misdemeanors since 2021. I've been off of parole since August 24. I know my record is not the best, but I'm working on changing. I will comply with probation, drug testing. I will do alcohol and drug assessment, anger management treatment, and mental health treatment. My family needs me out there, and I need to be with them. The time I come in front of you, I have 57 days jail time credit. If I mess up probation, I'm willing to do my time in prison. I ask that you waive the PSI and just continue the sentencing today. My job is on the line, and so is my house. I would not have any contact with the victim, Lindsay Frank. The protection order and the protection order and the no contact order can both stay in place. Please let me out on bond, OR bond. I have to be back at court for Lebanon Municipal Court for driving under suspension on the 13th for a $100 fine. That's going to show you that I'm trying to work on things. I'll have my fine paid off by the time we come back to court. That's all I ask for.
All right, so what proposed here today, Mr. Stutz, is that you are going to enter a plea of guilty to one count of violating a protection order. And we're going to set this for sentencing in January. How old are you?
32 years old, sir.
How far did you go in school?
8th grade.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
Yes, I am. Not that it's mind-altering or anything. I'm just seizure medications and bipolar medications.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No, sir.
Are you a United States citizen?
Yes, sir.
We've had some discussions with the attorneys about the case. If you enter a plea of guilty to this charge, I'm not going to sentence you today. I am going to do a pre-sentence investigation because I think that we need a PSI if I'm going to properly sentence you in the case. So we're not going forward with sentence today. And my inclination, Mr. Stutz, is to have you serve some local jail time and then release you into the community, put you on probation, and if you don't abide by the terms of the no contact order and the protection order, send you to prison. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document titled Change of Plea and Entry. On the second page is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Swift before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of guilty to one count of violating a protection order. It's a 5th-degree felony punishable by up to 12 months in prison and a $2,500 fine. There is no mandatory prison in the case, but I've already told you sort of where we're headed. If you violate and I do have to send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. Mr. Harris, what are the facts? And also, have we had the opportunity to confer with the victim?
Your Honor, I have received a victim impact statement today via email, so that's the only contact. I haven't had personal contact with her, but there was an email that was sent into our office.
All right, what are the facts?
Your Honor, if this matter proceeded to trial, the state will show beyond a reasonable doubt, in addition to all allegations in the indictment as to count 1, that on or about September 17th of 2025, while an inmate at Montgomery County Jail, the defendant Andrew Stutz violated a protection order by attempting to contact Lindsay Frank, who is located in the city of Lebanon, Warren County, Ohio. Defendant has previously been convicted of violating a protection order, and there was a protection order in place, which was granted on August 7th of 2025, effective through July 25th of 2030.
Anything on the facts, Mr. Swift?
Nothing.
Mr. Stutz, did you hear those facts?
Yes, sir.
Do you admit they are true?
I believe yes, sir.
Do you understand the rights you're giving up by entering your plea?
Yes, sir.
Which plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. We're not going to go into the matter of the sentence today. I'm going to order a level 2 pre-sentence investigation. We're going to come back here in the middle of January for sentencing. I am not going to release you today, Mr. Stutz. I want to see a pre-sentence investigation before we do anything.
Will the court consider work release privileges for him?
I will not consider any kind of modification of his bail whatsoever. Not until we get back for sentencing. All right, we'll see you in January, Mr. Stutz.
Thank you, Your Honor.
Thank you, Your Honor.
This is the case of the State of Ohio versus Andrew Stutz, case number 25 CR 43089. Present before the court is Mr. Stutz, right?
Yes, sir.
Represented by Mr. Swift. We have Mr. Harrison, the prosecutor's office, and we have Officer Henry from probation. Victim Ms. Frank is also present. We are here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor.
Any reason not to go forward with sentence today?
No, Your Honor.
We have 95 days of jail time credit. Does that sound right to everybody?
Yes.
All right, Mr. Harris, on behalf of the state.
Your Honor, the defendant has a lengthy criminal history of violence. He has been to prison before at least 3 times. And I think what stood out to me, there's a number of issues on the PSI, including mental health, substance abuse, violence. Victim in this case, Ms. Frank, is in fear, and I think the defendant knows that and even stated that in the PSI. He knew why they were there, that he is putting fear in the victim. In talking with her, she does not want any contact with him. I think it's come to that. I know she is here. She would like to make a statement before sentence is passed here today.
Ms. Frank, what do you want to tell me? If you could just stand up, Mr. Swift, you could just slide over just a little bit.
First, I want to thank you for allowing me to share with the court today how Mr. Stutz's actions have impacted my life. This is deeper than just a protection order violation. This is the aftermath of almost 5 years of domestic abuse. Psychologically, the constant gaslighting, controlling, blaming, deprivation of contact, harassment, coercion, and threats have left me afraid of almost everything. I no longer feel that I can trust anyone because of the trauma bond that I have with him. I no longer feel safe in my own home or even out in public because I live in fear. Fear of being harmed by him or his friends. Fear of what might happen next. I don't sleep peacefully. I wake up to panic attacks and nightmares, afraid that I'll open my eyes to my house on fire, or that he'll follow through with the many threats that he's made against me and my family. If it's okay with the court, I'd like to address him directly.
Go ahead.
Michael, you seem to believe that because you never left visible marks, that what you did to me for almost 5 years was somehow okay. But the truth is, the marks you left are permanent. The damage cannot be undone, and the scars are engraved deeper than any eyes can see. I prayed for you, for your safety, your health, your heart. I prayed for God to help me help you. I prayed for strength, for patience, and for the means to keep our lives together even when I was falling apart. Instead of leading, providing, and growing with me, you neglected me multiple times. You dragged me through hell and didn't care about the damage it was doing to me or what it would continue to do for years to come. Your addiction may have been yours, but it changed everything about me. You punished me with anger, with violent outbursts, and by disappearing at all hours of the day and night, leaving me wondering where you were, what you were doing, and why I wasn't enough. Each time you left, you drove me deeper into a dark place mentally, a place that I struggled to get out of even till today. You isolated me from my family and friends with your paranoia and your threats to hurt me, my children, and even my family whenever you didn't get what you wanted. You accused me of being too much or starting arguments when all I wanted was to be heard, loved, and understood by you. Financially, you put me in horrible situations. I still owe money for loans I never wanted to take out, loans I agreed to because I feared what might happen if I didn't. You made other people believe that I was crazy, unstable, or dramatic, but they never saw the version of you that I saw. They only saw the version you showed them, the man who helped everyone except the woman you loved. You wanted control over everything, my medical decisions, to make sure you could keep doing whatever you wanted while I lived in fear of being silenced, hospitalized, or dismissed as unstable. I lost faith in the person who saw me breaking and still chose to break me more. You knew I was tired, exhausted, trying to find my way back, and you still made me question whether love or loyalty ever existed. It's heartbreaking how someone can look you straight in the eyes, see your pain, and still choose to cause more of it. That kind of cruelty changes a person forever. It makes you colder, quieter. The constant deprivation of communication, the silent treatment, burned into my brain the idea that I'm worthless, that my feelings don't matter, that my reality is a delusion, and somehow I caused the abuse. Now I struggle to maintain any kind of relationship, whether platonic or romantic. I struggle to trust anyone, even myself. My heart's broken, and I know it will take years to begin healing the damage that you caused. Because of you, I no longer walk into a room without looking for exits. I no longer drive home without checking my mirrors, wondering if I'm being followed. I no longer sleep through the night without fear. You've taken so much, my peace, my sense of safety, my confidence, my trust, and those are things I'm still trying every day to rebuild. But despite all of that, I'm here still standing, and that's something you can't take away from me. I want you to know, Michael, that I'm no longer your victim. The fear you planted in me will not define me forever. You are not the man I prayed for. You're the man I stayed for far longer than I should have. And today I choose myself, I choose peace, and I choose to finally be free. I forgive you for what you think you didn't do.
Mr. Henry, anything from probation?
Nothing further than what was discussed, Your Honor.
Mr. Swift?
Oh, Your Honor, Mr. Stutz this is a low-level felony. He's been in for 95 days. He does have a residence to stay at. His girlfriend is here today in the back of the courtroom where he can go. And I think he's moved on from this relationship. And so I know he wants to move on with his life. We'd ask the court to give him an opportunity on CCS.
Mr. Stutz, anything you want to tell me?
Yes, I apologize to the court and to Lindsay for making her feel that way. It was never my intention. To be honest with you, she came back into my life after, I want to say, a year and a half. I contacted her after one of my previous relationships dispersed, and I think this is a misunderstanding. I don't want Lindsay in my life. I've moved on. I'm close to losing my job. I'm trying my best to move on and to better my life. I've been back on my mental health meds now for over 6 months. I've been locked up not just for you, but through probation, through Miamisburg for 6 months. It was August 7th I got arrested, and I have no conduct reports at all since I've been locked up. I'm really ready to move on and just show the court that I can do what I need to do for probation and then get off of probation.
So, Mr. Stutz, there's basically two ways to look at this case. Go ahead and send you to prison as a punishment for what happened, or put you on probation, and hopefully that will provide you with an incentive not to have any contact with Ms. Frank in the future. I think that's probably the better way to go in this case. So I am going to put you into my community control program on 5 years of basic probation. I'm going to impose upon you the standard rules of probation, but I'll be honest, Mr. Stutz, I've already told Officer Henry I don't want to put a lot of work into you. I want you to continue to take your mental health medications And I don't want you to have any contact with Ms. Frank. Those are pretty easy conditions to satisfy. As long as you satisfy those conditions, I aren't going to see each other anymore. I'm not going to impose a fine. I am going to impose the costs. I'm going to give you credit for the 95 days that you have already done. If you violate the terms of your supervision or you leave the state without permission, I can sentence you to up to the maximum penalty in this case, which is 12 months in prison plus an optional period of post-release control of up to 2 years. It does make sense to have you supervised on electronically monitored supervision with a curfew for the first 45 days. Let's make sure that we have a smooth transition into the community. Anything else we need to do? Anything that I forgot?
I'm working a job in Aberdeen, Ohio. Sometimes I get called out to the trailer park in Maysville, Kentucky. Is that going to be an issue?
As long as you're going there for work and you let your officer will make that work. All right, finally, Mr. Sutch, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript or to pay the cost, they'll all be provided to you without charge. Good luck to you.
Sorry for interrupting. I
That's
will
all
be
right.
on house arrest.
You're going to be on supervision with a curfew. So usually it's 8 o'clock a.m. to 8 o'clock p.m., but if your work takes you out past that, make accommodations for you in that regard.
So there's no ankle monitor?
There will be an ankle monitor.
There will be?
Yes. Okay, good luck to you, Mr. Stutz. All right, we're back on the record in the King case. We have Mr. Harrison, the prosecutor's office, and Officer Henry from probation. We're here today, Mr. Stutz, because I've received a report that alleges that you have violated the terms of your community control in that you demonstrated an unwillingness to be supervised and you were not able to provide an acceptable residence for electronic monitoring. Officer Henry, tell me what's been going on in this case since we were here last.
Yes, Your Honor. On the same date this case had proceeded with sentencing, Officer Ballin from the Community Corrections Department had reached out to Mr. Stutz about getting him started on GPS supervision. It is my knowledge that when it was explained to him that we would need to have verification provided for the address that he wanted to stay at, that was not able to be provided. Mr. Stutz had made a statement to the correctional staff that he wanted to speak with the mental health team, that if he was not able to speak with them, they would have to care flight him out of the jail as perceived to be threatening suicide. Correctional staff ended up searching his cell and found a tied noose to his top bunk that was hidden underneath the sheets. And according to Sergeant Laird, Mr. Stutz was placed on suicide watch to where he was immediately started smacking his head on the concrete walls, and he reported that they had to remove him from the cell and replace him in a restraint chair due to this self-harm. After speaking with the mental health team, speaking with Mr. Stutz, it is my recommendation that a further assessment needs to be made to take a look at an alternative placement for Mr. Stutz, where his mental health can also be addressed, but also any housing issues can be addressed as well.
So, Mr. Stutz, it seems like we're trying to get a plan together. We had a plan that didn't really address all of these mental health needs. I don't know that I was as aware of those as maybe I should have been. The plan is to set this for another violation hearing maybe at the end of the week and hopefully have a plan in place by then. What do you want to tell me about all of this?
My girlfriend is staying with family, and she can't provide a lease agreement and a bill, but I am allowed to go there. So that's where the misunderstanding came into place. I was hoping I could go to sober living. I was approved through mindful healing before, but I thought I was getting out on probation, so I denied it when they came back and asked me for who they needed to send the letter to of acceptance. I had talked to Erica, so I'm hoping that I can go to mindful healing. Again, it was the one out in Middletown. There I can address my mental health. She said before that she could take me to my appointments, doctor's appointments and such. I felt like on last Tuesday, that I got my hopes up to get released, and everything just crumbled. And I'm trying to get back out to the community and be with my wife or girlfriend, and I really hope that the court can see that I had one episode and I'm taking my medicine. I've been on my medicine since I've been in the jail. I'm really trying to get back on my other medicine that the jail doesn't allow, which is my Seroquel, which helps with my bipolar and my schizophrenia.
All right, well, here's what we're going to do, Mr. Stutz. I'm going to set this for, we'll know something by Thursday, right, Officer Henry?
I would imagine so. The referral, I'll have it set by today. My optimistic hopes would be that either DeCoach or Mindful Healing would be able to get him assessed by tomorrow morning or the next day.
Say something?
Sure.
Coach won't accept me because I have seizures. Mindful Healing was the only one that was willing to accept me.
Generally speaking, DeCoach, if they won't accept, they will help with referring to other treatment agencies as well.
Yeah, I wasn't trying to interrupt you or be rude.
That's all right. Let's go ahead and set this on Thursday. Let's put it at 10:45, and hopefully, Mr. Stutz will have a plan in place by then. Mindful Healing seems like a decent alternative to this. We need to figure out a way to get you out of the jail, but I do understand what you're saying about, oh, this is just one episode, but a noose in the cell is a very terrifying prospect.
Yes, sir.
Because the thought is, the next time there's a noose in your cell, there might be a person in it. So we need to make sure that we are exploring a higher level of care. So let's come back on Thursday. Hopefully we'll have a plan in place. My goal is to get you into Mindful Healing, someplace like that, out on a monitor, and reboot this case back in the community.
Is Nova House an option?
We can reach out to them. It's the issue regarding like expediency might become an issue with Nova House because they usually have a wait period for getting new clients.
Usually it takes a little while to get some people into Nova, but I am an all the above right now, so let's find out the best option and we'll get them there.
Okay.
Okay? All right, I'll see you on Thursday.
Thank you, Your Honor.
Thank you.
Case of the State of Ohio versus Andrew Stutz, 25 CR 43089. Present before the court is Mr. Stutz, right? We have Mr. Harrison, the prosecutor's office, Officer Henry from Probation. We're here today for a final violation hearing. Here's where we're at, Mr. Stutz. You know, Officer Henry's been listening to your jail calls, and all you talk about is cutting off your monitor and heading out. And
I actually told my wife that I wasn't going to do that.
I think we have a decent plan, sending you to Genesis, and then sober living after. And I mean, I am going to put you on EM, despite your representations that kind of make me think that we're not going to get our equipment back. Because I still think that this is the right way to go in this case, Mr. Stutz. Just incarcerating you, sending you to prison, something like that. That's not the way to go in this case. We need to get this treatment. So I am going to order that you enter into and successfully complete the Genesis program. You're going to be confined to the Genesis program while you are on EM. That means if you leave the program without permission or you cut your monitor off, you will be prosecuted for an escape charge. Eventually, when they catch up with you, I'll send you to prison. Okay?
Yes, sir.
All right. Is there anything else we need to do today? We have
105 days.
5 days of jail time credit.
Yeah.
Genesis with electronic monitoring.
And Your Honor, just to reiterate, we have reviewed the home waves, our victim advocate, and that was brought to my attention that it was kind of going back and forth. So whether he was going to comply or not, but he even indicated on the home wave that he would be prosecuted for an escape if he does cut. And I guess you've already reiterated that to him, but that is where the case will go if this occurs.
Yeah, I mean, the reality is I am not going to comply with the terms of my probation. It's not in and of itself a violation. So we're going to give you the benefit of the doubt, Mr. Stutz. Don't disappoint us.
It's just a lot, it's a lot of work for everybody, and it's gonna be more time for you.
Okay.
Okay?
Yes, sir.
All right, anything else?
I was hoping to be able to go to mindful healing.
That's the plan after we do the Genesis program, so sober living like mindful healing, someplace like that, right?
We can do either. Mindful does also provide PHP as well as Genesis. It was both placements that were secured.
Oh, okay.
Yes.
So we're thinking mindful healing right out of the chute?
We can, yes.
If that gets more buy-in from Mr. Stutz, I'm okay with that.
Okay.
We have somebody in the courtroom from mindful healing. That's why I talked
Okay.
to-
If he cuts off his monitor, call us.
Is the
All right.
I appreciate it, Judge.
All right, that's all.